Clayton Cachado, the Judicial Committee Chair. Today we are meeting about Mr. Harlos's appeal to the Libertarian Party of Colorado Judicial Committee regarding the purported resolution of the LPCO board on July 14th, 2025. In the chat is the proposed agenda. Does anybody have any objections to the agenda or want to make any changes? All right. Do the committee members want to introduce themselves quickly? Mrs. Harlos?
It looks like she's speaking, but she's muted.
Yes, thank you.
Oh, and then you didn't hear what I said about the agenda too. I just said I wanted to note that it doesn't appear that anyone is here for the respondents. But on introductions, I think everyone knows me, so I'm Karen Ann Harlos. I was actually the chair of the Judicial Committee last term and resigned out of protest with the RFK Jr. thing. So on this particular case, since it's my husband's appeal, I reserve any speaking points since any member of the party can come to a JC hearing and speak, but I will not be voting on it. I don't think that would be proper.
Thank you, Mrs. Harlos. Mr. Hill?
Oh, I'm Darren Hill, and my first time on the JC.
Thank you. Mr. Hujurtsman?
Yeah, John Jersman, El Paso County. I was LPCO treasurer for a while, and I have been on the bylaws committee. This is the first time I've been on a judicial committee.
All right, thank you. And this is also my first time on a judicial committee. All right. I know Mrs. Harlos noted that there didn't appear to be anyone here for the respondent side, but they may join shortly and they'll have that opportunity if they do. Mr. Harlos, you have 10 minutes to speak.
Well, actually, I'm not going to need 10 minutes. I won't even need 2 minutes because everything that's in the written appeal is the entirety of my position. So if anybody has any questions on that, I'd be happy to answer them, but I think it's all in black and white on the appeal.
Okay, thank you. Is there anybody else that wanted to speak on the appellant's behalf or Mr. Harlos? Okay, anyone for the respondent side?
Not for the respondent, but if I may ask a question.
The floor is yours.
Of Wayne, what in your appeal, what do you think is your weakest argument in your appeal?
Well, I don't think there is a weak argument. This is a very, very simple process. It's just determining whether the board had the authority to determine the convention canceled. That was a validly called convention. The only people that could do that were the delegates that were at the convention. And they refused, in spite of what they said they were going to do, they refused to call the convention to order and then proposed that it was improperly noticed. But they didn't call it to order so that the delegates didn't have a chance to make that decision.
All right, I have a few questions for you, Mr. Harlos. After the hearing was announced, we discovered that the prior judicial committee had declined to hear the appeal. Do you believe your appeal is still in scope for the current JC?
Yes, I do. Their argument was that it was not done timely, and they're saying it was because of the time of day, not the day of the month. The countdown is per day, per our bylaws, and also per Colorado statute. So that was submitted timely, and obviously they have shown that they have a difficult time counting days, and obviously the hours don't make any difference at all.
Even if that is the case, which I currently agree with that, there's an argument to be made that that the JC has already made a decision.
I don't know what to do with that one, to be honest with you, Clayton, because at this point, if we have two differing opinions, the only place for that to be decided is at a subsequent convention or in the courts.
Okay, thank you. And I have one more for you. You mentioned that you would like to see the board merely express its opinion. Can you maybe provide an example of what you were looking to see?
The board certainly has a right to express its opinion, as does the JC, but they don't have the right to make a ruling on anything. The only people that can make a decision on anything are the delegates at convention.
Okay. Mrs. Harlos, do you have any questions or comments?
Yeah, I'd like to make, Wayne, can you mute? Yeah, okay. I'd like to make some comments to see if Wayne would agree, and if anyone thinks that I've said these to him ahead of time. I haven't, because actually, y'all had some good questions that aren't even ones I would have anticipated if I wanted to. So I'm going to give an example of an opinion. I don't know how closely Wayne's been following national. Probably not at all, thank God. But the LNC recently expressed an opinion declaring that Angela McCardle was unfit to serve on the LNC ever again, and candidates or whatever. They made an opinion about her fitness for future service. They made it clear that it was non-binding. Like, they can't tell the delegates they can't elect her to anything. So, Wayne, would you agree that that would be analogous here? The board can certainly say, in our opinion, those assembled in Hollyoak made the wrong decision and are mistaken about our bylaws. That the board would certainly be free to issue an opinion like that, just like you could issue an opinion that they think that the National Party adopting the porcupine was stupid and it should be the lion, as some people think.
Well, I think this is very much analogous to what happened, but our board has taken a different tack than what the national board did. All they did is gave an opinion and they let it lay at that. Whereas the previous Colorado board were trying to make a decision that they don't have any authority to make.
And I have, if you could mute, so I have one other, and this is kind of halfway to the JC, but I'm just kind of going to make a comment out there. And I don't know if Wayne would have an opinion on it. So, there's a certain window in the bylaws, and there's a last date by which a hearing should be set. Unquestionably, we were scrambling on the 23rd to set a hearing date. If in that interim window between submission and setting, if the JC at some point in there rejected the appeal, I do think there are principles of equity that we have some play with, that everyone has some play with, but they can't go beyond notice requirements, that the JC could change its mind. Now, we had a mid switch of JC, but it doesn't matter. The JC itself is I don't want to say corporate as in legally, but it's an entity onto its own. Its members may change, but it's still the Colorado JC. That as long as they're within that first 10 days in which they have to set the hearing, if at one point they said, nope, we're not hearing this, as long as they're within that 10 days, they can change their mind. As long as they meet the window to give notice to the members. Would you agree with that?
I would. That's the single most important thing, is making sure the members are kept aware.
That's all I have. The first one was directly a question to Wayne because I thought of an analogous situation. The other one was kind of thrown out to everybody, and I just wanted to see if he would agree with that.
I do.
All right. Thank you, Mrs. Harlos. Mr. Hill?
So my take on this is that not accepting to hear an appeal is not a decision. So I don't think that the previous JC made a decision. My other issue with it is if something is even potentially inside the window of time that a JC could hear it, the JC should err on the side of hearing the member. And they didn't do that in this case. They tried to nickel and dime the time away to not hear the member. There's also the inconsistency factor. They denied to hear his appeal due to time, but then they overran the time on the Goodman appeal and still heard that. So once again, shows more of their failure in timekeeping. Yeah, and I completely agree that this sounds like the board issued an opinion and not a binding resolution.
Mr. Hill, are you the appellant is purporting that they did the opposite. Did you just misspeak?
What do you mean?
Mr. Harlos, can you clarify?
I'm not quite sure I understand the entirety of that question. Would you state that again, Darren?
I didn't really have a question. This seems very straightforward to me. My point is that the just like you said, the previous JC has been and the board has been very inconsistent with their ability to keep time. The issue of saying that they didn't take this appeal because it was not timely is inconsistent with their position on taking the Goodman appeal, which ran out of time. And they still took that one. And then in the case of choosing if they were going to honor things down to the day or down to the hour, they went with, we're going to go with this down to the hour just so we can avoid hearing your appeal. Instead of erring on the side of hearing a member's appeal if there was a question of, does it fit within the time window or not?
Mr. Chair, I believe that was more of a comment than a question to me.
Correct. I don't have any question. This seems straightforward.
I know where our chair is. Let me ask, because I think maybe Mr. Hill misspoke, but I don't want to say that he misspoke. Part of the problem is the board has approved minutes, but they don't publish them anywhere. So the exact language that they passed, I listened to, but until it's approved by the board, but what they passed purported to be a binding resolution. They said, here it resolved, or whatever, that the Holyoke Convention was invalid. It wasn't be here it resolved that the board of directors believed that the delegates were in error, and it is our opinion it was invalid. So there's a fine distinction there. So I think where our chair got confused, you seem to have said the opposite, that
No.
Okay.
So on that front, I'm saying it is my opinion that what they have, that the board said should be only an opinion and not a binding resolution.
Gotcha.
That is my statement on the matter. I'm not saying that I believe that they only issued an opinion. I believe that that is the only power that they have in the situation. I'm in agreement.
Okay, thank you. That's where everyone was getting. I think, but the chair can correct me if I'm misapprehending.
No, I think we're all on the same page now. Thank you. Did you have any other questions or comments, Mr. Hill?
No, that's it for me.
Okay. Mr. Jersman?
Are you just looking for a comment?
Any comments or questions?
Well, when I did an AI search, Google search on whether or not a convention can be or an event can be canceled, and one of the opinions that I got from the AI bot was that uh, if the event is called by a single person, in this case the chair, then that person is authorized to cancel. And I thought, well, that's interesting. And I repeated the search and I got a different answer. So if an AI bot can pick it up, there's some opinion somewhere that says that Hannah could have canceled the convention without board action. I don't know how strong that is, probably not very. The other thing that concerns me a bit is that the Constitution, the makeup of our convention attendees on the 28th was just as one-sided as the Mises attendance a couple of years ago when they took over LPCO. And while I know maybe that's not illegal, I think it's put us on kind of shaky ground in a way. I mean, just as in a way, it's kind of as offensive as what the Mises Caucus did. Now, some might say, and including me, that they deserve it, but that's just my opinion for what it's worth.
I do have a comment to add here. At least it's my position. I believe Wayne agrees. No JC, including this one, has the authority to determine if the convention was valid. So going back to whether the chair can cancel or not isn't within our realm. That's not within the bylaws jurisdiction. What's being appealed is not whether the convention was valid. That's not the question before the JC today. The question before the JC today is if the board had the authority to declare it so when delegates in convention or a purported convention said that it was. The only authority that can overrule other delegates is a court or other delegates, not the JC, not the board. So that's the issue here. But to go a bit afield, to the subject that Mr. I'm going to mess up your name, Jersman, uh, stated is, I'm sorry, I'm just laughing at my utter inability to pronounce your name for some reason. And I could get away with it with Clayton by just saying the chair. Everyone that was in Mises or any other group could have come. They were fully aware that people were planning on coming. And I'll say this for the anti-Mises people too. In 2024, a lot of the people who are unhappy now could have came to that convention. And some did. Doug was there, John was there. But there was a bunch of people who didn't. So if something's one-sided, and it's not because people were unfairly excluded, there has to be some responsibility placed upon the people who didn't come. And I apply that equally to both sides. If we want to keep our party, whoever they are, if the Mises people want to keep whatever their vision is that I don't agree with, but it's theirs, or other people want to keep theirs, they need to come. But the issue before the JC today would be, I believe, utterly outside of our authority under the bylaws to declare anything valid. Some people might think that's unfortunate and might want to give the JC that or the board that power in the future, but they do not presently have that power. Now, with AI, asking AI parliamentary questions, they don't. This is just way too fact specific, and I can tell you, I use AI sometimes for my work, and it hallucinates. It's made up entire quotes of case law that doesn't exist. Like I was doing a freelance job. I'm sorry, I just want to give one example where it was talking about where you could file suit in Georgia against a government agency. And it says, this statute says you have to file it in the county where the agency is. And that seemed pretty clear. I almost trusted that. Then I went and looked up the statute and it doesn't say that at all. And I had to get into a big argument with the AI. Actually, I get in rage arguments with the AI and call it all kinds of names and stuff. And then it finally apologized profusely, and it did give me finally a proper reference, which is in the Georgia Constitution. But anyway, please be very careful and trusting AI, particularly on complex questions, not simple things like how much is the filing fee in Douglas County. You can trust it for that. But when you start getting pretty fact specific, it's not there yet.
Thank you for clarifying.
Okay, because we have so much extra time left, the committee might be willing to entertain any public comments. Was there anyone willing to make public comment? Okay, any remaining comments or questions from the committee members?
Yeah, one. Wayne, if you could mute, thank you. I just wanted this on the record again, as Clayton knows, and I think the rest of the committee members knows, I'm kind of doing the informal secretary stuff, so I will make a record of this meeting, and this is why I want to make this comment. Due to the controversy in the party right now, emails couldn't be sent out to all the party members regarding this hearing. Our bylaws just say notice has to be given. So I just want in the record that this committee paid, not the committee itself, but it was paid for by members to put an ad in the Denver Post about this hearing, which was the only means at our disposal, but that goes throughout the state. So notice requirements were satisfied is the word I'm just trying to use. I just wanted to have that on the record, and I will stick to the minutes or summary or whatever we're going to call it, the confirmation from the Denver Post. They give you a little legal confirmation of when it ran.
Mr. Chair, I think Daniel Lutz had his hand up.
Okay, do the committee members have any objection to public comment? Okay, Mr. Lutz.
I didn't have my hand up, no.
Wayne's hallucinating like an AI. Your beard's gotten even bigger.
Thank you, Mrs. Harlos, for the doing the publication. So. Okay, it doesn't sound like anyone else has any discussion points. Per the bylaws, the JC needs to reach a verdict within 5 days and then a report afterwards. I believe we can adjourn at this point.
Is it going to be an email vote?
Unless we have a meeting.
Okay.
Well, there's several options, Mr. Chair, if you permit. Just going by what I know from like the National JC, it's become more common for the national JC to like announce its decision with written opinions. But in the past, probably because there wasn't so much electronic, if the case they felt was simple, it's certainly possible. What I'm trying to get into is the JC, if it felt like, I'm not voting, so I have no opinion on this. If the JC wished to, it could vote right now and then issue a written opinion within 5 days. Or it can announce its votes with a written opinion. In any event, I'll have the notes for you guys tomorrow.
I do not wish to vote today. That's my personal opinion.
I would never argue with the chair.
Mr. Hill, Mr. Jersman, what are your thoughts over the next 5 days?
My calendar is open. What do you want?
Yeah, I'd like to hear what the intent is for next steps and see what we're gonna do.
Okay. We need to make a decision on how we're going to do the voting. So we could do a virtual meeting, a in-person meeting, or by email. The 3 ways that I can think of within the next 5 days.
I'd be fine with virtual or email. I'm fine with just even an email with sending in an email with my written opinion on it, and that being a vote. However you want to do it.
Mr. Jersman?
I agree with that. Email is the most flexible time-wise for everybody involved.
Okay, perfect. Email works for me.
Okay, and again, I'll have notes for you guys tomorrow if anyone needs to refer to that. For that, as far as I can tell, the past board, if they didn't do it de facto, they did it in practice, has repealed all of the standing rules that used to have time frames. But I would suggest that the board's previous time frame of a maximum of 3 days for an email vote, or until everyone has either voted or expressly abstained, would be a good guide, since that's what the party followed for years. So after a few days, as quote, like kind of doing the unofficial secretary duties, if the chair wants, I can start an email ballot. The first thing that will be on it will be my express abstention. So then it would just be up to everyone else to vote. They could take the full 3 days, or if everyone votes sooner, then it would be sooner. But it would be up to the chair, and I can assist him in any way he desires, whatever the decision is, to at least put something in writing. There's nothing in the bylaws that requires some huge written opinion, but it does kind of offer guidance if there is. All we're required to do is vote. There's no requirement for a written opinion, but it has been tradition for the very short time that this JC has existed.
Mrs. Harlos, I believe. Oh, sorry.
Oh, am I wrong? I read so many bylaws that please correct me if I'm wrong.
Sure. I'm looking at.
I'm going there too.
Article 9, Section 8, subsection B. It says a report of the case and its verdict must be uploaded to the party website within 2 business days. Presumably, that's after the 5 days of the adjournment.
Yes. And that's on the board. We can't upload it. So if they, whatever, I can put it on Lpedia, which is a national party owned asset. And, don't want to get all Roberts, but General Roberts says, anyway, it doesn't matter. I'll get it on a party asset, whatever it is. is what I'm saying.
I-
Okay, you're
I-
correct.
I think that's the best we can do under our current circumstances. So, although we can certainly submit it to the group in control of the assets.
I assume in an email vote that everyone should use a reply all for transparency in responding
Yes.
to the, yeah, thank you.
And Mrs. Harlos, if you could send that email out, that sounds like a good suggestion to me.
Okay, so I figured I'd send the notes out, make sure everyone has a copy of the actual written appeal that was submitted, because I know so many emails have been flying about, just so that no one has to search for it. And then, like on Tuesday, I'll start the email ballot and we'll have till Friday. Or do you want me to start it earlier? I could start it Monday.
Is there a advantage to waiting?
Well, it gives everyone time to read the notes so they don't feel pressured into voting. You know, I wouldn't want to send the ballot out the same day I send out the notes from the recording from the meeting. But it's up to you. Just whatever you instruct me to do. I'm put a big note here so I don't forget.
Okay. Yeah, one day after the
Okay.
sending of the notes sounds reasonable to me.
Okay, I'll do that and I'll do the notes tomorrow. I got to do my Douglas County minutes too. It was our Douglas County meeting was literally 1 minute. So I'm not sending out minutes, I'm sending out the minute.
All right. Thank you to Mr. Harlos, the committee members, and the other LPCO members for attending.
So are
I
we
believe-
adjourned? It's 12:34.
Yes, ma'am.
All right. I hope you all have an awesome day.
You guys too. Thank you.
Bye-bye. Bye-bye. Thank you, Clayton.
Thanks all.